Good morning, and welcome to the second episode of our on-site construction webinar series. I'm Rebecca Williams, co-head of WFW's London Dispute Resolution Group and a specialist in construction and engineering disputes. I'll be hosting and moderating today's webinar. Today's webinar consists of 4 bite-sized presentations lasting around 10 to 12 minutes each. There'll be a short Q&A session at the end of the 4 presentations. So I'd like to invite you all to take the opportunity to use the question function through the Zoom platform to raise any questions. And we do like these sessions to be as interactive and as useful to the attendees as possible. The focus of today's seminar is in relation to issues, both technical and legal, relating to combustible cladding. This is one of the single most important issues facing the UK construction industry, which, as we know, sadly arose out of the Grenfell Tower fire in June 2017, as a result of which 72 people tragically died. As of March last year, it was estimated that in London alone, there are 2,000 buildings that may need rectification work as a result of the cladding which has been installed, and at an estimated cost of £4 billion. The ramifications for residents and stakeholders in the industry are obviously huge. And whilst the government announced in last year's budget the establishment of a £1 million fund to help replace combustible cladding on housing blocks higher than 18 metres, and the draft Building Safety Bill introduced last week proposes to extend the limitation period for bringing claims relating to substandard construction work, there is still much uncertainty in the industry as to which stakeholders are likely to carry the burden of identifying and replacing combustible cladding. The situation is all the more complicated by the fact that in a great number of cases, the combustible cladding was approved for use and complied with the building regulations and applicable safety standards at the time it was installed. Today's speakers will provide helpful insight into the key issues and help clarify some of the uncertainty around risk and responsibility. First up, Bart Kavanagh, Technical Director, and Paul Jolly, Associate Technical Director at expert consultancy HKA, will address some technical aspects of Rainscreen cladding in the areas of risk, regulation, and responsibility. Next, Barry Hembling, a partner at in WFW's Real Estate Group, will consider the new health and safety duties for developers, consultants, contractors, and residents. Desai, a partner in WFW's Dispute Resolution Group, specializing in real estate disputes, will consider who is responsible for combustible cladding, the landlord or the tenant. Finally, Ryland, also a partner in WFW's Dispute Resolution Group, who specializes in construction and engineering disputes, will look at recent updates in case law relating to cladding issues. We hope you will find today's presentations informative and useful. And again, please do take the opportunity to ask any questions that you have of our speakers. I will now hand over to Paul Jolly and Bart Kavanagh.
Thank you, Rebecca. Good morning, everyone. The word cladding has been used extensively in the media following the Grenfell disaster, and this can encompass a variety of different systems and material types. So today we're going to provide a brief introduction into what is collectively known as Rainscreen cladding and consider some of the associated risks, regulations, and responsibilities. So on the next slide, we can see examples of alternative cladding systems, including panels made from painted metal, colored laminates, terracotta tiles, and timber boarding. And as the name implies, Rainscreen cladding involves applying a screen of lightweight paneling over the outside of a building to offer improved weather protection. These modular systems have proved to be very popular when compared to more traditional forms of construction, such as site-laid brickwork, because they can be applied relatively quickly on new build projects, as well as refurbishments involving existing buildings. The diagram on the next slide shows how typical components within a Rainscreen system come together. So starting on the right-hand side and working outwards, we have the external wall of the building, onto which is applied a resilient, water-resilient breather membrane. We then have the thermal insulation layer in yellow, which is what keeps the building warm. And finally, the cladding panels and the associated support frame, which importantly is installed with an air gap behind or a cavity. And this allows the open jointed paneling system to be drained and ventilated. So on to the next slide. There are risks that cladding systems may contribute to external fire spread, depending on the type of materials that are used and how they are installed. These diagrams explain the key stages associated with external fire spread through a multi-story building. The diagram on the left shows how a fire might behave in a typical building where the external cladding system is not contributing to the fire propagation. So if a fire was to start in a flat and continues to develop, it will start to attack the unprotected areas within the external wall construction, such as the window openings. And when the fire breaks out, this then has the potential to cause a secondary fire by attacking the windows on the floor above. And then this process is repeated by jumping up to the next floor once the fire develops further. However, if the Rainscreen cladding system itself is providing a medium for external fire spread, as shown in the middle diagram, this can lead to a rapid increase in the rate of fire spread, which can lead to multiple secondary fires occurring simultaneously, as shown in the diagram on the right-hand side. So there are really two principal ways in which the cladding system can contribute to a fire. Either the materials and components within the system are combustible, or the air cavity behind the panels is unrestricted, which allows smoke and flames to spread rapidly through the system like a chimney, as shown in the central diagram. So the next slide takes the first of those two risks and illustrates how different components within a Rainscreen cladding system have different classifications in terms of how they may contribute towards a fire. So here we've shown 5 different types of thermal insulation products as an example, but equally this could apply to other components within the system, such as the cladding panels, the support frame, or the breather membrane. The table on the left shows a simplified version of how materials are graded under the European standard in terms of their combustibility. So this runs from class A1 non-combustible at the top down to class E and class F at the bottom, which are considered to be easily flammable. So set against this table, we can see on the right-hand side that the mineral wool is classed as a non-combustible material that would have no contribution to the fire, whereas expanded polystyrene at the bottom is likely to have a high contribution. So in order to minimize the risk of fire spread, designers need to ensure that the materials they're specifying within cladding systems comply with the regulations regarding the building type and also the building height. The next slide illustrates the second key area of risk in the cladding system, which is concerned with the ventilated cavities behind the cladding panels. This diagram shows how a building is typically broken down into a series of separate fire compartments, typically one per residential flat. And in order to protect against fire spreading from one compartment to another, it's important to install cavity barriers around the edges of all the window openings, which prevents fire and smoke from entering the cladding system through the weak points in the facade. As shown in red, the cavity barriers are also required along all the fire compartment lines, which includes the floor slabs and the party walls. And this breaks the external cavity down into smaller restricted sections. So again, it's very important for designers to ensure that cavity barriers are correctly specified within Rainscreen cladding systems to protect against these risks. And I'll now hand over to Bart, who will be discussing more on the regulation side.
So if we could have the next slide, please, which I think will show you the cover page of Building Regulations 2010 edition, but the previous edition as well in 2000, covered these issues in Part B, which deals with fire safety. Now, the regulations themselves set out only functional requirements. They give a very broad description of what you're needing to address, and guidance on how to meet these requirements is provided then by a series of approved documents. And approved document B, commonly referred to as ADB, deals with fire safety. If we could go to the next slide, please, we'll see approved document B. And paragraphs 12.5 to 12.9 in approved document B deal with external wall construction. 12.8 and 12.9 deal specifically with cavity barriers. And because this is relatively straightforward, and Paul has explained them, I think, as much as we need to, we won't be dealing with paragraphs 12.8 and 12.9 any further at the moment. Now, paragraph 12.5 gives an overview of the regulations related to cladding, and states that the external wall construction should either meet the guidance provided or meet the performance criteria given in BR 135 when tested in accordance with BS 8414. Paragraph 12.6 deals with cladding materials, and paragraph 12.7 deals with insulation materials. Now, these are critical elements because in practice, the application of the ADB guidance to some materials and products can give rise to some anomalies. So we're going to look at the guidance and then see how it might apply to some of the commonly specified materials and products, beginning with the next slide, please. So we'll see that paragraph 12.6 refers to diagram 40, which is also in ADB. And this simply requires cladding materials to have a fire classification of either class 0, which is a UK classification, or class B S3D2, which is a European classification. Paragraph 12.7, dealing with insulation, requires the insulation to be of limited combustibility. And that's defined in Appendix A, Table A7, as an A2 classification, as Paul indicated a little earlier on. That's one of the European classifications and is material of limited combustibility. So this sounds very straightforward. How hard can it be to select materials with stated properties? Nevertheless, the application of these guidelines to actual products and materials is the root of many of the disputes that we find ourselves dealing with today. So let's have a look at some of those materials. And if we can have a look at the next slide, we can begin that. And on the left-hand side there is a diagram of aluminium composite material. And it is essentially 2 sheets of aluminium, normally less than 1 millimeter thick, sandwiched with a core of a material. And the core of the ACM can range from metal honeycomb down through mineral, as you can see on the slide there, and down to polyethylene, which is the most inflammable type. Now, that list of core materials is given in increasing combustibility, but all of them, including the polyethylene core ACM, have a classification of class 0 and therefore would comply with the guidance given in paragraph 12.7. So that sounds great. They all comply with paragraph 12.7. However, following Grenfell, the Ministry for Housing, Communities and Local Government commissioned a series of 8414 tests. And it was discovered that ACM with a polyethylene core failed to meet the criteria in BR 135, even when it was used in combination with non-combustible insulation like mineral wool. And one fire officer described its performance as being akin to solid petrol. So therefore, although ACM with a PE core complies with the guidance provided by ADB, the cladding system which incorporates it will not comply with the functional requirement of the building regulations. So an anomaly. This is really an anomalous situation within the regulation documents. But if we go on and start to look at insulation, only insulation products made from mineral wool, glass wool, or foamed glass will meet the classification set out in Table A7 for limited combustibility. However, the MHCLG tests did demonstrate that polyisocyanurate foam, commonly referred to as PIR, and by extension phenolic foam, which performs slightly better, can meet the BR135 criteria when they're used in combination with the less combustible ACM cladding panels. In other words, they can meet the functional requirement of the building regulations, but the system must be tested in order to satisfy the guidance of 12.7 and demonstrate compliance. Now, even before Grenfell, manufacturers of such insulation products, phenolic or PIR, were carrying out tests on their cladding systems, which incorporated their products. And the results of the successful tests were included in their literature and in BBA certificates relating to the products. Now, these tests led generally to the perception that the products were generally safe, and at least in one instance, a manufacturer was claiming that its phenolic product could be treated as being equivalent to mineral fiber. Now, on the one hand, a detailed interrogation of the literature and claims might reveal that caveats should apply, but many designers relied upon the information published in technical documents and BBA certificates. And bear in mind here that when we're looking at this, we're looking at all of this with the benefit of hindsight. At the time these buildings were designed, designers were relying on information that was available at the time and not really having a disaster like Grenfell in mind. So to summarize the position with regard to the regulations, we can see that following the guidance provided by ADB may not always result in satisfying the functional requirements, and also relying on manufacturers' certificates and literature can result in failure to follow the guidance in ADB and to test systems that need to be tested. So if we move on to responsibility, this is really a tale of two standards, I think is the way to look at it. And one is a contractual requirement to comply with the building regulations, i.e. to satisfy the functional requirements. And this is likely to apply to a contractor in relation to a developer client, or to a developer in relation to purchasers of the property, or other interested third parties, people with collateral warranties, or who are mentioned in the contract as having third-party rights. The other requirement is to exercise reasonable skill and care. And this is the requirement that will almost certainly apply to the designers. And there's a strong argument that responsibility would be discharged by following the guidance of ADB, which we've seen will not necessarily guarantee that you're going to comply with the regulations. There may also be arguments related to relying on the published technical literature and BBA certification. I think they're less clear as to how strong they will be, and that would vary from case to case. So in any event, this can lead to a situation where an employer or contractor can face claims for breach of contract where they have a contract with a clause complying with building regulations. But they may find that they're not easily able to recover any losses incurred by way of damages from designers who rely on the use of reasonable skill and care in their defense. There are no cases on any of these issues yet, so these are all questions without answers. Not many months ago, I got within a weekend of the TCC on something very similar to this, but the parties settled on the Friday night, so we'll never know what the outcome was going to be. But anyway, there we are. I hope that's been helpful, and thanks very much.
In this next session, we're going to look at the draft Building Safety Bill, which was published last week. So this is the government's attempt to reform a system for regulating building safety that's rightly been criticised as not fit for purpose. Now, the background to the bill is, of course, the tragic events of the Grenfell Tower fire. So that should never have happened in our country, and we continue to remember those who passed away just over the 4th anniversary of the fire. So the bill seeks to do two things. Firstly, it seeks to rebuild trust in an industry censured for a culture of ignorance and indifference to safety. And secondly, the bill is intended to accelerate the rate of repairs on buildings with unsafe cladding. In terms of the current position, it's worth reminding ourselves that 4 years after the Grenfell Tower, Grenfell Tower fire, as seen on the next slide, remedial works are still incomplete on 55% of buildings with the same dangerous ACM cladding type as installed on Grenfell Tower. And over the next couple of slides, I show the breakdown of those buildings. So mainly private housing, social housing, student accommodation, hotels, and publicly owned buildings. And then in the next slides, time doesn't permit me to dwell on these, but they're there in the pack if you want to have a look at them. They identify the rate of progress by reference to all buildings, by reference to private residential, by reference to student accommodation, and in relation to hotels. So as you will see, the context of the Building Safety Bill is that more work needs to be done to rectify and to accelerate the rate of repairs in current buildings that are identified as being dangerous. In terms of what it means for future projects, it's worth reminding ourselves that the background to the bill is, of course, the interim findings from Dame Judith Hackett's report on building safety. So you recall she was the former head of the Health and Safety Executive. Her report recommended a new intelligent system of regulating and enforcing building safety, and her recommendations have been adopted in the draft Building Safety Bill. So the bill highlights work to new and existing high-rise buildings and the cut-off of buildings that are 7 stories or more. And the idea of that is that the higher-rise buildings often lack sprinklers to be found in other high-rise buildings, such as in commercial offices and hotels, and which may be beyond the reach of most fire rescue equipment. And it's worth saying that the draft Building Safety Bill goes beyond the recommendations of Judith Hackett in her report. Some areas of her report have actually been exceeded in the draft Building Safety Bill in a number of areas. So what is clear is that the draft Building Safety Bill can't be ignored by those who only work on residential buildings of 6 floors or less, or those who do not do any residential work at all. And that's for a number of reasons. Firstly, parts of the bill apply to buildings of 7 stories or less. Others apply to multi-occupancy residential buildings, such as student accommodation or senior living. And even if the bill doesn't apply directly, it's likely to become influential because its measures are likely to be a benchmark for best practice in the construction industry. So in the remaining part of this talk, I'll look at some of the major themes coming out of the draft Building Safety Bill. The first theme is collaboration. So that's said to be the principle on which the new regulatory regime is founded. So there'll be a new health and safety regulator comprising local authority building standards, fire and rescue authority, and the health and safety executive. Secondly, there'll be an expansion of the existing system of confidential reporting to cover fire engineering safety concerns on all buildings alongside their current operating system on structural safety issues. There will also be strengthening of the oversight and regulation of construction products to make manufacturers' responsibilities clearer. There will also be periodic review of the system for building regulation safety and ongoing continuing professional development. So the idea is that duty holders who have duties under the Building Safety Bill need to ensure that their skills are kept up to date so that they have the skills, the knowledge and the expertise to discharge their functions effectively. The key idea behind the Building Safety Bill is that there'll be a golden thread, which will be a more stringent approach to accountability over the lifespan of a building through a digital record that's held electronically to identify the original design intent and any subsequent changes to the building. Those changes will be captured on that digital record and preserved to ensure safety improvements in the future. There would also be new duties on the client, the principal designer, the principal contractor, and other accountable persons who must establish a system to facilitate reporting of fire and structural safety issues. That system of reporting will be around 3 key gateways. First of all, gateway 1, before the planning permission is granted. Gateway 2 will be before construction begins, and the third gateway before occupation begins. And the idea is that the duty holders will replicate the existing duties under the CDM regulations. So the principle behind the measures is that there should be someone responsible at each stage for managing and mitigating fire and safety risks throughout the building's life cycle. Looking at some of the changes in detail, the first issue is design changes. So it's envisaged under the Building Safety Bill that designers will be involved from the very early stages of a project. They'll be also required to assess the impact of any design changes and the impact of any value engineering proposals, and will be expected to form a view to ensure that a building safety design has not been compromised. They'll be required to maintain a more detailed contemporary record confirming what changes were instructed and why safety assessments were made in response to a change by way of an auditable record of safe construction. There will also be a new digital record covering the high-rise buildings that will cover the initial design intent through to construction and recording any design changes that have occurred and the reasons why. This suggests, as the next slide shows, that there will be more detailed record keeping. In terms of developers, they'll be expected to establish a case for safety. They'll be required to identify that case through each of the gateways. So they'll have to gather together the evidence to satisfy the building regulator regarding any fire safety risks and fire safety issues. And they'll also need to show that they are considering fire safety risks and that they're being assessed on an ongoing basis. In terms of contractors, they'll be expected to demonstrate that what's been built reflects the design that they've been given. So what we may see are increases in the role of clerk of works, checking the design during construction. And contractors will be expected to maintain a more detailed contemporary record of what's been built. During occupation, the building regulator will decide whether to issue a fire safety certificate for the occupation phase. And to make that assessment, they'll want to see what's been designed, what's been built, and whether the building is ready for the occupation stage. And it's expected that the building safety regulator may attach conditions to the registration certificate to ensure that building safety risks continue to be monitored and mitigated. And the idea is that the safety case will be reviewed periodically by the regulator during the occupation phase to ensure that the risks are being monitored on an ongoing basis. Perhaps one of the most significant introductions in the Building Safety Bill is the idea of co-signing compliance with building regulations upon completion. So this will no longer be the responsibility of improved inspectors, but something that contractors and designers will be expected to actively participate in. The idea is that if building contractors and designers co-sign compliance, they will only do that if they have greater knowledge about what has actually been built and designed. And co-signing will be supported by new civil liability for building regulation breaches that result in damage. These proposals won't apply retrospectively, which perhaps confirms how the current building regulations are in places confusing and contradictory. But the measures will make a significant difference to future projects because current homeowners potentially and those that are subject to the building regulation civil liability requirements could benefit from a right to sue those potentially who have co-signed compliance for up to 15 years. And these proposals could leave developers, contractors and designers with a 15-year liability period for non-contractual claims. In terms of what the Building Safety Bill does for existing projects, the idea is accountability. And the Building Safety Bill provides existing homeowners a right to sue for up to 15 years under the Defective Premises Act. So the Defective Premises Act requires consultants, contractors and developers working on a dwelling to carry out their works in a professional or workmanlike manner, to use proper materials, and to ensure that the completed works are fit for habitation. Now, the risk is that the extended rights under the Building Safety Bill could be undermined by an absence of insurance. That's because whilst claims under the Defective Premises Act usually equate to negligence, that's not always the case. And the important point is that under the Defective Premises Act, a party can still be held to be liable, but not negligence. Now, that distinction is important because professional indemnity insurance policies respond to breaches of reasonable skill and care. So if a consultant was negligent, but was not negligent, but produced a design that was not delivered in a professional manner, they could still be liable under the Defective Premises Act, but insurance cover may not apply. So this could result in parties having to face claims without the benefit of insurance. And that could be a real risk because parties may not have the benefit of insurance, and homeowners may not be able to enforce judgments in the absence of insurance because those who they obtain judgments against simply may not have the ability to pay. And also giving retrospective effect to Defective Premises Act claims, but not to civil liability for civil building regulation breaches, is another example of where the bill creates a two-tier system. So the key is really that you need to start preparing for these changes now. They're going to be introduced over the next 9 to 18 months. And in terms of what you can do about it, I think there are 3 key takeaways that you need to start considering now. Firstly, there needs to be consideration as to whether there are any existing projects that will be caught by the extension of claims under the Defective Premises Act, which will apply retrospectively for up to 15 years. So projects from 2006 could now face themselves with Defective Premises Act claims under the Building Safety Bill. So parties need to review their existing projects and see whether any existing projects might be caught by these measures. Secondly, parties should speak with their insurance brokers. So they need to find out whether professional indemnity insurance will be available for retrospective projects and what steps they need to take to ensure that insurance cover remains in place. And thirdly, they need to start thinking about what systems they need to put in place to comply with the idea of this golden thread, which will involve greater record keeping, review of design changes. So how will systems be put in place to ensure that the greater record keeping requirements can be complied with? So the Building Safety Bill is currently going through Parliament. There will inevitably be some changes that are made during its passage. And here are some points to look for as the bill transforms into an Act of Parliament. And there are 3 points to look for. First of all is the extent to which the bill will continue to create a 2-tier system. So I've touched on some of those points, and there are already examples where there are going to be 2-tier regulations for construction. So there'll be one regulation potentially for buildings up to 6-storey, and then there will be other regulations that will apply for buildings of 7 stories or higher. So potentially neighbours within the same complex could be subject to different regulations depending on how high their blocks are. And it'll be interesting to see the extent to which that that continues to apply going forward. And again, we've got this idea of 2-tier system with claims whereby those under the Defective Premises Act will apply retrospectively. Those for civil liability breaches for building regulations will not apply retrospectively. And it will be interesting to see whether that distinction remains. Secondly, we need to understand more about the implications for civil liability for building regulation breaches. So this could be a major extension of non-contractual liability. And it could mean, for example, that collateral warranties might be made redundant because it may no longer be necessary to put these mini contracts in place if parties have a right to sue for non-contractual claims as a result of civil liability breaches. So we need to understand more about this and how that will work in practice. And finally, perhaps the main point of the bill is that the bill still assumes that homeowners are best placed to take responsibility for rectifying defects within their homes. In fact, homeowners are often the parties least equipped in terms of expertise and resources to solve the problems of unsafe cladding on their homes. And that perhaps is the major flaw of the bill, because it still places too much responsibility on homeowners when they don't have the resources or the wherewithal to do that. A rethink is required on that issue, and we'll continue to keep all of these developments under review, and we'll provide an update in future on-site webinars. Now I hand over to Desai, who will provide some updates on a landlord and tenant perspective.
Thank you, Barry. Well, Barry's talked you through the new building safety bill and the stringent measures that it introduces for construction works and new housing developments. What he called the golden thread of safety risk information running through the life cycle of those new buildings. But how about existing buildings? Even if there is a claim against a construction professional involved in the cladding, in the meantime, remedial works may be necessary. Who is liable for that work and who will pay for it in a typical scenario of a residential building with leases of the whole or parts, such as flats? Is it the landlord or is it the tenant? I advise on residential blocks of flats, hotels, care homes, and student halls of accommodation once they've been constructed. What I've learned from my 30-odd ongoing cladding cases is that the respective rights and obligations of landlords, tenants, management companies, and other interested parties are very different once the building is built and capable of residential use. Today, I'm going to talk to you about how the law decides who is liable for the safety of cladding and fire safety, and in general terms, what they are expected to do. The main piece of legislation that governs who is responsible, as you can see from this next slide, is the Regulatory Reform Fire Safety Order 2005. The order applies to commercial premises, the common parts of multi-occupied residential buildings, and once it's brought into force, the Fire Safety Act 2021, which clarifies and in some cases expands on what parts of a residential block are caught by that legislation. And as you can see on the slide, it extends the ambit of and the subject matter of the obligations to the structure, external walls, of course, the windows and doors in those external walls, and doors between common parts and residential apartments, to the extent that leases don't already determine and clarify those points. There are lots of other contractual and statutory provisions and common law that are relevant. The Health and Safety at Work Act, the Defective Premises Act that Barry's mentioned, Occupiers Liability Act, various laws of tort. However, I don't have a 2-hour speaking slot today, so I'm going to stick to the basics and general principles. So, the essential question to ask to identify the relevant responsible person under the order is, as you can see from the next slide, who the contractual obligation to repair and maintain is applied upon. The essential question is to identify the relevant responsible person under the order is a question of contract. And as you can see in this next box, where a person such as a landlord or a tenant has an obligation of any extent under a lease or a contract in relation to maintenance and repair, that person is treated as though they are in control of those premises. This is important because, as you can see in the third box, the person in control has the statutory duty. That person is responsible. There are a couple of points to note here. The landlord or the tenant must have the obligation and not just a right to maintain and repair. This is often a pivotal distinction in cases I deal with. Also, legislation can impose duties on multiple parties in relation to the same premises. Several different people may be in control to a lesser and greater extent. However, generally speaking, in premises let under a FRI lease, a full repairing and insuring lease, I would expect that this will usually be the tenant of the whole building or the management company with repairing covenants. In a multi-let building, it is usually the landlord that is the responsible person. As you can see in this next slide, the order essentially says that the responsible person has a duty to take measures as is reasonable for a person in that position to ensure, as far as is reasonably practicable, that the built premises are safe and without risk to health to building users. I mean, what does that actually mean? Well, Bart and Paul of HKA have already outlined some of the material intelligence and analysis that goes into this. But typically in matters that I deal with, you're usually looking at an initial desktop fire risk assessment, analysis and verification of the external wall system composition. And that might call for an intrusive survey, someone to go up and actually look at what the material is and carry out lab analysis. And ultimately, out of all of this, a risk assessment needs to take place, and as a consequence, remedial action may be required. The next slide sets out a section from the advice from the Ministry of Housing, Communities and Local Government, issued in January and then again in November 2020. I won't read it out, but it encourages the application of building regulations combustibility criteria in assessing existing residential buildings, including those that are below 18 meters. This advice, I think, has the indirect effect of expanding the ambit of responsible parties' statutory obligations. After all, it would be difficult for a relevant duty holder to show that they had taken all reasonable measures for a party in its position if it's not followed the advice that the government has repeatedly given. The greatest source of dispute often in my case is outlined in the next slide around ultimately who pays for necessary remedial works. A week or so ago, obviously, we saw the draft building safety bill. And for me, it is a mixture of some very substantive cases, changes, and some window dressing. But the bill does amend the Landlord and Tenant Act 1985 in order to address some of the problems in service charge provisions and regimes in existing leases. It will imply terms into long leases of flats in high-rise buildings. I won't go into the details of those, but essentially, under those terms, the landlord must make a commitment to the leaseholder to carry out the necessary remedial measures and apply any financial support available, for instance, from the government. In turn, leaseholders agree to pay a fair share of reasonable charges and cooperate with building safety regimes, such as by granting access to their premises. So there is some light at the end of that tunnel. I'll now pass over to Ryland, who will talk you through some interesting new case law developments in relation to cladding.
Thank you very much, Joe, and thank you to everybody for joining us this morning. So, as an overview of my rather short presentation, I'm going to start with the background to why we've had this presentation and what are the issues that are before the courts and how they started to deal with the issues that we've heard about today. So since the Grenfell tragedy, of course, there's been an increase in these cladding cases. And I think we're really at the beginning of that process, sadly. But I think that there have been some developments which will be helpful or reassuring to people and the stakeholders who are interested in these issues. The issues relating to both the legal questions and the factual questions are complex. When it comes to the legal issues, some of the issues that we need to think about is, and these have been foreshadowed by the other speakers, the contractual question about who was engaged, who is now responsible. And those contractual issues can then extend to questions of negligence and tortious duties, particularly on those who've been involved in the approval or the design of certain cladding systems. In terms of the factual matrix, that's even more complex in some ways, because as the HKA speakers explained, there's lots of different issues to consider, and also investigations need to be done at the right time, and they need to record exactly what's been installed. And so you have to go over the factual matrix and you have to look for records. And you know, as Barry says, we need to improve on that, because on many projects there just simply isn't the quality records that you'd hope there would be, and hopefully that will improve in the future. But on an upbeat note, the courts have shown that they're willing to be more liberal about these types of claims, and I'm going to outline fairly quickly a summary of 4, I think, key cases over the last couple of years which demonstrate this liberal attitude of the courts. So moving on to the next slide, the first case that I'd like to summarise is Martlet Homes and Mullally. Now, this is a 2021 case that was before the High Court, and it was to do with the refurbishment of 5 tower blocks owned by Martlet Homes, and then transferred to a new owner. And this is a JCT design and build contract. And like many of these cases, they do start generally with a design and build contract, because it seems to be that parties believe they've got a stronger case, perhaps against a contractor who's also designing these cladding systems. Now, this was originally a claim for defective works for an array of issues. And what happened was we got to the reply stage in the litigation, and the contractor, the claimant, issued a reply arguing new cladding issues that hadn't been pleaded previously in the claim. And so the issue before the court was, can they do that? Can you introduce cladding issues at the reply stage in litigation? And what the court said was, no, you can't. And it's not that it's a cladding issue, it's because you've missed the boat. Your case needs to be properly particularised with all of the issues that you want to put before the court in the particulars of claim at the beginning. So the court said, sorry, too late, we're not going to allow you to introduce a new cause of action at the reply stage. However, the court then said, well, as they tend to do, well, on the one hand, we're not going to give you something, but we may give you something with the other hand. And what the court said was, you can have permission to amend your particulars of claim. So the court's showing flexibility there, that although strictly speaking, you can't introduce new issues, not the reply stage at least, they went on to say, actually, you can introduce this new claim by way of amendment. And so this is a case that's ongoing, but it's an indication of that flexibility starting to emanate through the courts. And obviously this is a case that we'll keep a very close eye on to see, hopefully we get a judgment, but often these cases will settle and we won't know much more. But I'm sure over the coming months, we'll start to see judgments like this one come through and give us more guidance about who is responsible and who should pay for rectifying cladding. Moving on to the next case. This is between Naylor and RomeQuest, and this is a 2021 case as well. And this is a case, a claim by residents of a development block for defective cladding. And in this case, we had some cladding that was installed, which was an aluminium composite with K5 materials. And I know from my own experience that these are very widely used, or certainly they were. And so I think this case will be one to watch. As you'll see in a minute, it's not been completely decided finally, but this was an interim issue, which again shows the sort of direction of travel. So the claimant had, it was said, failed to particularize the claim properly in respect of this defective cladding. Now, again, the court said, look, you can't bring a claim to court that's not properly particularized. The courts just won't accept it. However, they did say you can have the right to bring this claim in principle. What you need to do is you need to go away, you need to properly particularize it and come back to court. So again, flexibility in relation to the way that the courts are allowing these claims to go through is certainly encouraging for those that have been affected by these issues, but obviously it raises concern for those contractors and subcontractors and developers and owners who are worried about whether these claims can be made. But there's no question, if you don't particularize a claim properly, then it's liable to be struck out. But in terms of principle, the idea that you may have issued something late or not quite as well as you could have, you can sometimes get off the hook if you've got a generous court, which at the moment in their mindset, we certainly seem to have that with certain judges, at least in the High Court of England. Moving on to the third case, this is a case between RG Securities and Allianz, and this is a 2020 case. And in this case, there was an application by the defendant for summary judgment on the basis that the claim had been issued out of time. So I wanted to raise this case because I think it gives us a good example in relation to the Limitation Act and the flexibility, it seems, that the courts are affording parties to bring claims, well, I say late, but in certain circumstances, they're trying to find ways to give parties a second opportunity to possibly bring out of time claims. So in this case, what happened was the court said, although the claim is technically out of time, because the failure to obtain building control sign-off at the time was concealed, the court said, well, obviously we can't allow you to get away with that. You're hiding the fact that you didn't get building control sign-off in relation to these cladding issues. And insofar as you've concealed that fact, that resets the clock for the purposes of limitation, and therefore the claim could proceed. So this question of concealment is obviously something that could be investigated, where perhaps the parties haven't been entirely upfront about whether or not the building did comply with building regulations. And that comes back to the factual matrix. What records were in play? When were the inspections taking place? Who witnessed those inspections? And what was said or conveyed at the time? And concealment could be that you simply just don't create any records of something that happened, on the basis that you're trying to withhold that information from the other party. And of course, the courts won't let you get away with that. So the court's again saying there are ways around some of these limitations. Moving on to the next case, Sport City. Now, this is an interesting case. We've got another JCT design and build contract, and it's for defective cladding. And this is a claim slightly different to the others insofar as it was brought by the management company. Now, I think that was really the key issue that decided this case, the fact that the party was the management company. Because what happened was this claim was challenged on the basis that effectively the management company had no right to bring that claim. And in fact, the courts agreed with that approach and they struck out the claim. They said that the lease, although the lease was between the landlord, the defendant developer, and the claimant management companies, the covenant in the lease related to the quiet enjoyment and the construction work were made by the landlord and not by the defendant developer. And therefore, the action was effectively against the landlord and not the developer. So the key point here is to look at the terms of your leases as to see where your rights sit, who might be responsible, and obviously the right party bringing the right claim. So it demonstrates how cladding claims, again, brought by residents who are not party to favourable leases, building contract or collateral warranty, can prove to be difficult. And there was another point that I wanted to make on this case, which I found interesting, or 2 points, in fact. One was that the court went on to say that this claim was time barred in any event because it was beyond the 6 years. And they also said that the claim that was brought in the alternative for negligence and or under the tort of negligence was in fact one that would fail in any event. And the reason the court said that that would fail was because the claim was for pure economic loss, and you cannot recover pure economic loss for a claim in negligence. So the court's giving quite good guidance there, I think, to the industry and to potential claimants about the type of claim that they can bring and how the courts will deal with those in due course. Moving on to the last slide then, in conclusion, obviously, as I said earlier, there's going to be more and more cases to be decided, but it seems to me that there's a sense of flexibility about the courts, which want to give the benefit of the doubt, if you like, to claimants, which will obviously be a concern to contractors and to developers and to landlords and landowners. So there's a balancing act here, and it's very important that everybody takes stock of what the obligations are and gets advice as soon as possible in relation to those issues. And I've no doubt there'll be more claims and more guidance coming through the new building safety bill, which Barry mentioned before. That's me done. Thank you very much. I'm going to pass back to Rebecca now, I think, for some Q&A.
Thank you very much, Ryland, and thank you to everybody else. That was really informative and interesting. Before we start the Q&A session, I'd just like to thank everybody today for taking the time to attend and obviously again to the speakers. We have received quite a few Q&A questions, a few questions. And so I am now just going to turn to the first one. And I think, Bart, I'm going to nominate you to respond to this one.
Okay.
So, yeah. So
Hope it's one I can answer.
I'm confident that you will be able to answer it. The question is, does the panel have a view on the EWS1 form? Should it have been introduced, and is it fit for purpose?
I do have views on EWS1 forms. I think they've been greeted with some dismay amongst the professionals because there's little guidance as to how they should be filled in. There's quite a restricted expertise that really is necessary in order to be able to complete an EWS1 form. Lots of risk and getting PII cover is somewhere between impossible and extortionately expensive. And given those restrictions and those difficulties, I think that it's easy to make an argument that they're not fit for purpose. However, I think that's a widely held view, and the landscape is going to change slightly. The British Standards Institute, for example, is introducing a new British standard. It's at the PAS stage at the moment, PAS 9980. I happen to be on the drafting committee of that. And it basically is giving guidance in making risk assessments on external cladding. It's effectively analysing or looking at the risks and looking at what needs to be done in order to assess a risk, in order to make a reasonable assessment of the risk associated with any particular building. And given that that risk assessment then will be linked to a British standard, I think the aim is that insurance will be easier to achieve, and also consistency in risk assessments across the board will be easier to achieve. And whether the EWS form then continues to exist in its present form, or whether it adapts to a form which is more closely aligned with the PAS as it is now, and the British standard as it will be, remains to be seen. But that's the situation at the moment. Thanks.
Thank you very much, Bart. Okay, I've got quite a few questions. So one of the questions actually relates to limitation, actually, which I'm sure is going to become that's going to be a topical issue. The question is there any legal remedy for claims for homeowners against other parties in relation to cladding that were built before 2006, as these will not be covered under the new bill? I am going to nominate Barry Hembling.
Thank you, Rebecca. So I think it's going to be very difficult to bring claims if the block was essentially built before 2006, and that's when the cause of action accrued. I mean, a lot's going to depend on the contract when limitation was agreed, but the idea of having this 15-year period for non-contractual claims and under the Defective Premises Act is to bring non-contractual claims in line with the arrangement for contractual claims, which are generally subject to a statutory 15-year long stop, subject to what the parties agreed. So I think in terms of what potentially could be done, I mean, we touched on it in Ryland's presentation. So the idea of concealment, the RG Securities and Allianz suggest that where there's been an element of concealment, the limitation period is reset. What that means in practice remains to be decided. And we don't know, for example, whether that concealment still means that there'll be a 15-year long stop. And I think we need to find out a bit more about that. And potentially there's some arguments that could be raised in that respect. And the other is also in relation to human rights. It could be said that the absence of being able to bring a claim potentially impacts on human rights. And it's interesting that under the Building Safety Bill, parties who are responsible for the installation of defective cladding can use a human rights defence if a retrospective claim under the Defective Premises Act breaches their human rights. But that's not an action that may be open to residents where their buildings perhaps were beyond 2006 and so outside the limitation period. So there might be something there that could be done with human rights, but it all remains to be seen, and there's a number of areas there to be fleshed out and developed.
That's a really interesting point, the human rights angle. Thanks very much, Barry. And actually sort of allied to the last question, I think, and it comes back to concealment. I have a question here which is essentially, I wonder whether the panel, particularly Bart and Paul on the technical side, and the WFW partners on the legal side, have experience of practical indicators of deliberate concealment. I mean, I'm sure it will crop up. Claims under the DPA by residents are common, but often time barred in principle, subject to demonstration of deliberate concealment. Obviously, does anyone want to comment on that? Bart, you're putting your hand up.
I can. I wouldn't say that it's common, but I did have a case where we were initially called in to investigate some water damage, and it became apparent that there were fire-related issues. And when we started to investigate and remove the cladding, there were virtually no cavity barriers in place. And it was clear that there had been cavity barriers put in place and that they'd subsequently been removed by the subcontractors who were installing the cladding. And the cladding was just installed, and you would never have known there were no cavity barriers there unless there was some reason to go and open up, or a fire occurred, which would have been an awful lot more devastating than it would have needed to have been.
Sadly, it's not wholly unsurprising.
No, that's not the only instance of that we've come across. It's not hugely widespread, but it does happen.
Yeah. So I have another question, well, quite a few, but I'll just pose a few more. The question is, there seem to be so many anomalies concerning buildings under 18 metres, such as the asker of this question. Why should we accept having potential expensive remediation works when the RICS guidance excludes buildings under 18 metres? Does anyone have a view on that? I'd like to take that question.
I can pick that one up if you like.
Thanks.
Well, I suppose that the blunt answer is that the Royal Institution of Chartered Surveyors isn't the arbiter of, certainly not conclusively, of what would be reasonable fire safety measures and remedial works in relation to a building. Government guidance has suggested that certainly those combustibility criteria should be applied to buildings that are under 18 metres. And each case obviously has to be taken on its own facts. You can quite see that a building under 18 metres with, say, more vulnerable residents, a care home, for instance, the cladding in those kinds of cases might need to be looked at by the responsible person, even though just from a pure height matrix point of view, it doesn't fall within that criteria.
Thank you, Dev. Okay, I'll just ask another couple. This question is: will all the new legislation, particularly the extension to the limitation period to 15 years, apply to buildings less than 6 stories? Barry?
Well, we think so, yes, that's right. So we think it's a general right to claim under the Defective Premises Act, regardless of the height of the building.
Thank you.
Rebecca, just on that point, it's open, the government's left the door open to change that height level in relation to even where regulations currently apply. So, watch this space for a change in relation to that. This position in Scotland is already different. It's 11 metres rather than 18 metres. And just last year, the government consulted on changing the position in England. And so it's a moving feast.
Does anyone want to express a view as to whether that anomaly should exist or whether there should be that distinction? Don't worry if you don't want to stick your neck out. Ryland, I'm making eye contact with you.
I think it should apply, just as a matter of common sense and as a matter of principle. I think, look, these new standards and the guidance should be taken to the furthest possible point that they can be taken, so that people are protected. This is about public safety, and so I think that absolutely, if there's any ambiguity, it should be read in favour of safety, is my view. I also had another point, if I could just raise it, because I'm sure on the limitation point, I'm sure that developers and contractors are probably very concerned about this extension to the limitation period, opening the floodgates to a lot of claims being made. And I know the flip side, of course, is that it gives comfort to those in occupation. So it's a balancing act. But I just wanted to mention that in the Building Safety Bill, there's a caveat to that extension, which says that unless it's finally determined or agreed between the parties. So there could be scope for contractors and subcontractors and developers coming to contractual arrangements whereby they full and finally settle all obligations that they may have, so that they're not then caught by the extension to the limitation period. And I think what the second thing that says is that obviously if there's a case or a determination by an arbitrator, possibly the final determination of those issues, the idea is that it prevents double jeopardy. And you would have thought once it's been resolved, then you can't bring another claim just because the limitation period has been extended. So that would be the end of the matter. So I thought there's 2 points that I think people should be sort of take a bit of comfort from on that side of the fence.
Thank you. I think obviously the panelists have access to the various questions that have been posed. If anyone would like to, if there's a question in particular that anyone would like to address, I'm happy to ask another question generally of the panelists. Is there one that piques anyone's interest in particular? Don't worry if not. I think this is an issue that is definitely going to become very topical and crop up. We've already seen, Barry, I know you and I have discussed the PI market, and certainly I'm seeing that crop up a lot, where it's very difficult. You obviously have the contractual obligations on the one hand that require contractors in particular to take out PI insurance of particular duration with particular indemnity limits, and we're increasingly seeing that's very difficult to obtain. So this question is that PI insurance for 15 years, run-off cover, would be unattainable for SME, and the cost of PI for 6 years is currently 400% and upwards. Does anyone want to express a view or share their experiences, and essentially what can be done to address the issue? Because I currently have two disputes, or I'm advising on 2 projects where it's just simply not possible to attain in the market the insurance which is contractually required. It's Barry, I think you've said that your personal experience is that you can get the cover in the aggregate, but not on an each and every claim basis. I mean, my personal view is that people have to be sensible, have to work together, and you have to vary the contract in those circumstances. But over to you guys.
Well, I think the risk is that what they've done is essentially made retrospective cover for Defective Premises Act claims without the certainty of knowing that there's going to be insurance in place to cover them. So we don't know, for example, if insurers are going to now step in, having thought they would close their books in relation to projects from around 2006, and whether they will now extend cover. I mean, it remains to be seen what the reaction is from the market, but it doesn't seem as if there's been a coordinated approach between liability on the one hand and insurance on the other, which otherwise puts small businesses then at the mercy of having to face claims without the insurance cover to back it up, and leaseholders potentially suing parties who may not have insurance cover to pay. So a lot needs to be seen on this.
Yeah, agreed.
I could just add from our experience on the architectural side that the PI cover is a huge issue, that premiums, I think, have gone up typically 300, 400% post-Grenfell for architects. And many architects are now unable to actually get insurance for projects that may involve issues relating to fire safety. So they have to expressly exclude those from their appointments. So I'm not sure what the answer is, but it certainly is a huge issue.
Okay, there are so many pertinent and very good questions here that I simply can't resist asking a couple more. And I note there are quite a few participants, so I think I will ask a couple if everybody else is in agreement. I've got something at 11, but so whilst which is the one that I thought, okay. This question is a statement. Currently, the applicant and designers are the only people able to obtain copies of documents lodged with building control. And currently, BCO refuse to pass data to current and future homeowners are excluded. Should there be a change in the law to give access to information for future homeowners, including leaseholders? Don't know, Dev, do you want to take this one? Sorry to put you on the spot, or I don't mind. That's an interesting question.
I think I can answer that fairly shortly by saying yes. It makes sense for that information to be available to an interested party, rather than as a fishing trip for information, but someone genuinely interested, a prospective buyer, and flip it the other way. Why would you not have that information available? And perhaps others on the panel might have a view on that, but from my perspective, it seems like a no-brainer.
Can I just add a few words to that? I agree with Dev. I think that sort of information should be available in exactly the same way that you can log on to the planning portal and see all of the information regarding planning applications in your area, if you're a resident, or if you're an architect, the neighbouring buildings and that sort of thing. I suspect the reason it isn't is the same reason that building control authorities are effectively immune from prosecution, and that is for policy reasons, in order to limit the possibility of vexatious litigation. And I think that's something that really needs to be considered, because on the one hand, kind of this sort of area where there is a general concern could open the floodgates to all sorts of litigation, which is spurious or vexatious, ill-founded, because there is, it's such a complex area, and it affects so many people. But I think there ought to be a way, and I'm not making any suggestions here as to what that way might be, but to have some sort of access to the huge amount of information that's lodged with building control. And just from the expert, perspective, we also find it difficult to when we're trying to get hold of information related to a building that we're asked to provide an opinion on. And it's sitting with building control, and it can be very hard to get. So yes, it is an issue.
The other one, just to add to that, I think there could be a contractual route to obtain that information. So you could add provisions into your contract that say that you have a right to access that information. That's something to do perhaps at practical completion or as part of O&M manuals. There's nothing preventing you putting a provision in the contract, but make sure that you have access to all of those records.
Yeah, I mean, it's certainly true to say that I can't think of any information that you would expect the building control authority to have that wouldn't be available somewhere else. The difficulty is that the somewhere else's are often diffuse, sometimes non-existent. The contractor may have gone bust, the consultant may have gone into liquidation, and building control is a convenient one-stop shop, so to say. But if others are still, who were involved with the project, are still around, then it should be possible to get hold of the information. But I agree that building control would be a very convenient route for homeowners, for example.
I think one thing I'd add as a potential complication to that is that Barry's touched on the golden thread of information as an accurate record of the life cycle of the design of the building. What we quite often find as experts is that the drawings lodged with building control, and quite often what are termed as the as-built drawings, they actually can bear no relation to what's actually been built and installed on site. So there that there can be complications in that. Obviously, with the golden thread, the hope is that everything will be with these enforced gateways. The information will be regularly updated, and any changes in the specification will be caught and recorded. But as it stands at the moment, there are very often discrepancies in the information between what's designed and what's built.
I would echo that. In so many of the cases that I have at the moment, professionals such as Paul and Bart, will do a desktop analysis based on information that's might be available from disparate sources, and then eventually an intrusive survey is carried out, which reveals that in fact, for instance, the cavity barriers aren't in place or not adequately installed or whatever it might be. So that is a source of concern.
That is a nice segue onto what I think will be the final question that I'll pose of the panelists today. And as we said, we will follow up on all the other questions and make sure that you receive responses. The question is, whilst we've addressed cladding, a number of other issues are being identified by the intrusive investigations. And this is something, obviously, Bart, that you touched on when we were talking about concealment. For example, lack of fire barriers. Whilst this is not covered under the government current support measures through the fund, what remedy is there for owners who would bear the burden of this cost? Actions and negligence perhaps by the contractor for not installing in accordance with the drawing, latent defects, etc. Does anyone want to pick up that and express a view or offer some guidance? And then I think we'll probably have to wrap up for today.
Well, I can take just very briefly on the legal question there. I mean, the extension to the limitation period proposed by the Building Safety Bill isn't restricted to cladding issues. So all types of claims in relation to defective buildings could be made. So that's the first point. And then the issue is whether you can prove it was concealed if it's outside of that period, or if it's inside. Then your remedies would be the standard remedies, which would be, your contractual breach of contract or potentially tortious claims. Although, as I mentioned earlier, if it's pure economic loss, then you have a problem there. So it's really breach of contract. And the question then would be, can you prove that the standard or the requirement existed under that contract? And if there's a breach, can you prove the breach? And then lastly, are you in time? So they're the key issues, I think.
Just on related to the point that Ryland's just made, the Regulatory Reform Fire Safety Order 2005 also is of general application to fire safety in general and isn't limited to purely the cladding. So as between the live parties with an interest in the property, the landlord, the tenant, the management company, and so on, as between them, the order regulates and legislates for all sorts of fire safety issues, including cavity barriers.
Thank you, Deb. Thanks for that. That was very helpful. Okay, well, I think we're going to have to wrap up for today. But catch us on YouTube, obviously, should you wish to rewatch or revisit, and we will be circulating materials, etc., and answering the queries that remain. So thank you to all of the speakers. I found that really helpful, really informative. And thank you to everybody who took the time to attend today, and also for the very thoughtful and thought-provoking questions that everyone posed as well, because that always makes it more interesting. Okay, thank you, everybody. Bye.
Thank you. Bye.
Bye.